Welcome to today's program titled A New Standard. The NLRB resets the table for handbooks and policies with Cemex and Stericycle. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during the webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Chelsea Meza. Chelsea, please go ahead.
Thank you so much, and thanks to all of y'all for spending a little bit of your morning/afternoon with us to talk about these incredibly important topics that are near and dear to the hearts of the three of us who are on the call today. As was mentioned, my name is Chelsea Meza. I'm a partner in our Los Angeles downtown office. I'm also the lead of our national handbook and policy team, so I get the honor of handling these issues on a daily basis. Today, I am joined by two of our most esteemed members of our labor management relations group. First, Senior Counsel Jennifer Mora, she's also a dog lover, very important to note, and Senior Counsel and cycling aficionado Jeffrey Berman from our Los Angeles Century City office. I'm also on the next slide going to be taking you through our agenda, so you know exactly what we're going to be covering and you know what to expect. We will start with a little bit of setting the stage so you have a sense of where things were before what we are calling the perfect storm of Stericycle and Cemex. We will talk a little bit about those two matters, as well as the specific policies that we believe are most at risk because of them. And then we'll talk a little bit about overall handbook best practices, things to keep in mind while you are reviewing your handbooks. That we know handbook season is right now. And so it's a great opportunity to be looking at those. And this gives us a chance to do that with Cemex and Stericycle in mind. And with that, I will go ahead and kick it over to Jen, who's going to help us set the stage for where we are right now.
Thanks, Chelsea. And again, good morning and good afternoon, wherever you're calling from today. So glad to be here to talk about this exciting, if you're in the labor space, these are definitely exciting and interesting times. You know, over the last 2 years, employers have been bracing themselves for some NLRB rulings that we knew would drastically change the landscape and the way employers address employee and labor relations issues. So how do we know this? On the next slide, we can see a quote from President Joe Biden talking about his intent to be what he calls the most pro-union president leading the most pro-union administration in American history. Another quote he said during his candidacy was, "You can be sure you'll be hearing the word union plenty of times when I'm in the White House." And he pledged to, quote, "be the strongest labor president you ever had." His first step in that direction, if we could go to the next slide, was to fire the acting NLRB general counsel. The general counsel is responsible for litigation, and they really set policy at the National Labor Relations Board. Just briefly, the NLRB is what we would consider a politicized agency. When President Biden is in office, it is led by Democrats and a very pro-labor agenda, and when a Republican is in the Oval Office, it tends to be more pro-company, led by Republicans. So, like I said, he fired the NLRB General Counsel at the time, and he nominated our current NLRB General Counsel, Jennifer Abruzzo, and she took little time in releasing General Counsel memoranda. So those are documents that she puts out that highlight certain rules or requirements or kind of her vision for what the NLRB is going to look like under her term. And those memos, there were a bunch of them that came out back in August of 2021. So we've all been sort of bracing for some things to come out of those. On August 12, 2021, she issued a GC memo that specifically targeted handbooks and other workplace policies. More specifically, any of those policies that were analyzed under the Boeing handbook decision. Next slide. In 2017, the Trump board, which was led by Republicans, established a new framework for evaluating the legality of handbook rules and workplace policies. So under Boeing, the standard was that if a facially neutral rule may, when reasonably interpreted, potentially interfere with Section 7 rights, the board is supposed to evaluate both the nature and the extent of the potential impact the rule has on employee rights and the legitimate justifications for the rule. So it was essentially a balancing test. Why does the employer need the rule, right? You have to explain why you need the rule, and then you balance that against, well, what impact does it have on Section 7 employee rights? And if the employer is able to show that its justification for the rule outweighs the need for an employee right, then the employer would win under that standard. So post-Boeing, we saw a bunch of Trump decisions come out upholding a variety of rules. So we had pro-employer decisions on investigative confidentiality policies. We had some decisions that were favorable with respect to non-disparagement. And then we also had some rules regarding outside employment, and there were a bunch of others. Next slide. So the current chair of the NLRB during the Trump board was in the minority, and we learned a lot about where we might end up under the Biden board with McFerrin's dissent. And during her term on the board, under the Trump board, she issued very long and sometimes what I would call scathing dissents in virtually all of the decisions where the Trump board upheld an employer rule. And you can get a sense from this slide as to, these are direct quotes from her dissents as to what she thought about Trump decisions to the extent they found employer rules favorable to the employer, to what she felt was the detriment of the employee. Next slide. So we knew that the Biden board was going to ditch the Boeing rule in favor of something more consistent with McFerrin's view. We knew that because Jennifer Abruzzo put out a general counsel number essentially saying so. And at some point last year, the NLRB invited people and agencies and entities, employers, parties from both sides to submit amicus briefs to outline their position on what they felt the new handbook and policy rules should be. We thought, based on a number of McFerrin's dissents, that we were just going to go back to the Obama rule, which was that the mere maintenance of a neutral work rule will violate the act if employees would reasonably construe the rule to prohibit union and other protected concerted activity. That's what McFerrin was pushing for in all of her dissents. That's where we thought we were going to end up. What we got was something far different. And so I'm going to turn it over to Jeff, who's going to talk to us about two decisions that have prompted us to put together this webinar for you today. Jeff?
Okay, thank you. Good morning and good afternoon. I think what you've gathered so far is the political nature of the organization that we deal with, the National Labor Relations Board. The NLRB has been accused and is currently being accused of doing major flip-flopping. And so that the best way to figure out what you're going to have tomorrow is to look at what you had yesterday. So when we had the Trump board, we knew that when the Trump board was replaced, in the event that Biden lost his election, that what we'd have to do is to go back to the early Obama board. And so what you always do is you look to see what the party in who's outside of being in charge did on their case law, and you'll know what's going to happen next. And that's exactly what we've had here. We go back and forth on these employee handbook rules. The first case we want to talk about is Stericycle, and I think we're on the wrong, there we go. Can you go to the next slide, please? Okay, so Stericycle is a very important case, as Jen mentioned. Its part is flip-flopping back and forth between Boeing and Boeing's predecessors as to what is going to be the standard. As Jen mentioned, in Boeing, what you would do is you would look to see how is a rule to be reasonably interpreted, and whether or not it's a reasonable interpretation that the rule, which is facially neutral, like a rule, for example, that you are to treat your coworkers with respect, you are not supposed to damage company property. You look to see whether that rule could be reasonably interpreted as interfering with employees' Section 7 rights. And in doing so, you would balance the rights of the employer and the employee, and then make a decision as to whether the rule is lawful or unlawful. Very early on in her tenure, Jennifer Abruzzo, when she started talking about her view of the world, would start by looking at the preamble to the National Labor Relations Act, which can be construed as being a very, very pro-union statute, which is really how it started. And so everything that any position that Jennifer takes starts from the premise that it's employees and unions that have rights, because that's why we created the statute, and that the employer, what they want to do really doesn't count very much. So what they did in Stericycle is that they changed from the Boeing rule of just reasonable interpretation, whatever that is. And what you now looked at is whether the employee who was economically dependent on the employer, and they all are, and who contemplates engaging in protected activity, could they believe that the rule had a coercive meaning? So an example would be, for example, if a rule said that you are to treat your managers and all employees with dignity and respect, one would say that's facially neutral. But according to the Labor Board's view of the world now, is that a person that meets the Stericycle test, and we'll go into that in a second, if they thought that that meant that they couldn't yell and scream at their manager because the manager had violated their Section 7 rights, that would be coercive and would be interpreted as being unlawful. The General Counsel has, under the Stericycle, once you meet the first test of looking at the facially neutral work or rule, and whether an employee who is economically dependent and engaged and contemplated engaging in protected activity, that the rule was coercive, that then the General Counsel, once they've made that showing, which is easy to make, then the employer has a very hard road to hoe, and that is that they have to advance a legitimate and substantial business reason to justify the rule and to show that you can't have a more narrowly interpreted rule, a tailored rule. So let's go to the next slide. Okay, so looking at the Stericycle rule, we look at first facially neutral rules, and we start with the proposition that once the General Counsel takes a facially neutral rule, and that would be a rule that says nothing about unions or collective activities, that if the General Counsel is able to show that there's a reasonable tendency to chill employees' rights to engage in protected activity, the rule becomes unlawful. Now, there's nothing that tells us what reasonable tendency means and how we show it. There is no case law that I'm aware of where there's been testimony put on the witness stand that the board has adhered to or followed that says, well, I looked at this rule and my interpretation was this, or I looked at this rule and my interpretation was that, and here's why I'm reasonable. Here's why I'm a reasonable person. And that to make things worse for the employer, that we look at not only reasonable tendency, we look at reasonable employee, and we don't know what a reasonable employee is or how you prove it under the NLRB rule. And we know that we don't count lawyers in this because lawyers look at rules and they apply common sense construction to that. We don't look at what a lawyer would say. We look at the reasonable employee, and we look to see whether the employee is subject to the rule. And almost every rule in a policy or a handbook, all employees are subject to, unless there's a specific carve out. And we look to see whether the employee is economically dependent on the employer. And I can't think of an employee who is not economically dependent on the employer unless they're the owner of the company and they're working for $1 a year. And if the employee contemplates engaging in protected activity. So basically, you have to look at the rule from the eyes of the employee who is wanting to engage in protected activity. So it takes you away from just looking at what even a reasonable employee does or how a law can reasonably be interpreted. You specifically have to look at it from the point of view of an employee who relies on the paycheck from his employer and is contemplating engaging in protected activity. And protected concerted activity under the Labor Act is much more than union things. It's any time where employees get together for their mutual aid and protection about wages, hours, and working conditions. So if an employee goes and talks to their manager and says, I'm underpaid, that's not necessarily protected concerted activity. But if they go and talk to their manager and say, well, Joe and I think that we're underpaid, that's protected concerted. So the law goes way beyond union issues. It goes to lots of other things with employees getting together. Next slide, please. The employer's intent on maintaining the rule doesn't count under Stericycle. And remember, the big difference between Stericycle and Boeing is that Boeing was a balancing test, and you're trying to figure out, why is this rule there? Who does it benefit? Does it benefit the employer? Does it, is it act to the detriment of the employee? Here, whatever the reason is, so if an employer has the rule that says you're to treat everybody with respect and dignity, the fact that they're doing it because they'd had problems in the past, they'd had racial animosity, they'd had whatever it is in the past, that doesn't count anymore. We just look at the rule and not why it's there. And if the rule is ambiguous, it gets interpreted against the employer. So if the employee says, well, it wasn't clear to me what this rule meant, I thought it may have meant this, that's ambiguous unless the rule is specific as to who it applies to and what it says. So the interpretation of the employee, whether it was correct or incorrect, and whether it was consistent with the employer's intent, doesn't count at all. The next thing is that once you get to that, as I mentioned, that the employer has a very heavy burden. They have to show legitimate and substantial business reason that supports the rule and which can't be achieved by a more narrowly tailored rule. So if, for example, you have a rule that says we are to treat everybody with dignity and respect, and an employee starts yelling at their manager because he thinks that the employer treats their employees poorly, then the labor board under the current Stericycle rule would say, well, wait a minute, if the employee reasonably believes that they could be disciplined or discharged because they violated the rule of having common respect, that the employer would then have to show that they had a legitimate interest in maintaining harmony in the workplace, and that there was no way to draft the rule more narrowly. So for example, you could draft the rule that says you are to treat your co-employees and your managers with dignity and respect, and then you could tailor it narrowly by saying, except if you're engaging in protected concerted activities under the National Labor Relations Act. Or, for example, you could say you are not to engage in damage or damaged company premises or company materials. That would be a neutral rule that could impact an employee who was going to break something because they were angry about the way that employees were treated. So the rule would have to be you are not to engage in destruction of company premises or property unless, comma, you are engaged in protected concerted activities and you're mad about something. So that's the way I think that the board's going to come out to how you come to a more narrowly tailored rule. Next slide, please. The big hit is that the rule applies retroactively. We have a 6-month statute of limitations. So if you have a rule and it's been out there for continuously for any part of the last 6 months and continues, you're in trouble. So that there are rules that employers enforced that were lawful under Boeing and lawful under common sense, which are not lawful under Stericycle. And the labor board can reach back to those. And what the labor board did before Boeing is if you had, and this was under the Obama board interpretations, if you had any kind of an unfair labor practice, it had nothing to do with the policies and practices of the employer. The regions typically would ask you for a copy of your handbook, even though it had nothing to do with the case. And they would go through the handbook and they would look for everything that violated the then Obama board standard, which is now worse under Stericycle, and issue an unfair labor practice charge complaint. So things that you've done lawfully for the last couple of years now are unlawful, and they're unlawful retroactively. Now, the Stericycle rules don't apply to rules that explicitly restrict Section 7 rights, or that were promulgated in response to Section 7 activity. What they do is that they apply only to these rules that are neutral on their face. When you're looking at handbooks and whatnot, there are a bunch of rules that we know are going to take hits under Stericycle. And it wasn't very hard to interpret this. Under the Obama board, the general counsel issued a very long memorandum saying these rules are going to be unlawful. Then under the next general counsel, who was a Republican, those rules changed. And now we're back to where we were. So we know that the rules that took a hit under the Obama board were social media rules, audio and video recording rules, use of the employer's email systems, distribution, workplace conduct like being respectful and professional, bulletin board access, off-duty access, among other things. So when we review handbooks here, our handbook people put on one hat, which is they look at things for common sense, and then they go through and put on their NLRB hat saying, well, now, even though these things make sense, what is the labor board going to do with these very common things? And I was at a seminar not too long ago where there were current members of the labor board, past members of the labor board, and past general counsel. And the employer representatives took the position, well, look, why are you guys doing all this? These rules don't get enforced. The employees don't read the handbooks. And the response from the Democratic side was, if they don't read the handbooks, you won't get in trouble. Just don't have a handbook. And so getting rid of all policies and handbooks, I think, is the easy way out. So the takeaway is you need to review all of these rules and your policies, and probably things that you've had in there for a long time and make common sense are not going to pass muster. Next slide, please. So the second case we're going to talk about is Cemex, improperly referred to often as Cemex. Thank you, Jen. And what this is, this sounds like it's more procedural. The NLRB, or the NLRB, has an election process that we've all looked at forever. And what has happened is that a union goes out and typically gets authorization cards signed by employees, saying that they want to be union represented. They go to the employer and say, we've got authorization cards, we want to represent your employees. And the employer says, no, we don't think that authorization cards are a reliable means of determining whether employees really want to be represented, because you could have lied to them, you could have threatened them, blah, 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 blah. And so we want to have an election, then you'd have an election. And we're all used to having elections in the United States. Well, the Democratic board is not so keen on having elections, though that they know that they couldn't take away the right of the employer to have elections totally. So they came up in Cemex with sort of a hybrid. So what happens now is if the union makes a demand on the employer for recognition based upon cards or signatures, if the employer has a couple of choices. One is that they can agree to say, yes, we'll waive the election. We'll believe that you've got the cards. We're not going to go ask the employees. Or if the employer says, no, we're not going to recognize you, then the employer has 2 weeks to file its own election petition. Now, remember, traditionally what's happened is that the union asked for recognition, the employer said no, and that the union had to go in and file the election petition. Now the employer has a choice of doing one or two things, and that is recognizing or filing its own election petition. If it doesn't file its election petition, it's in trouble. It basically now has a union. Now, if the employer files the election petition and wins the election, but it turns out that it engaged in what we call objectionable conduct, and those are things that can be unfair labor practices, but they can be things that just influence the conduct of the election, but they're not necessarily strict violations of the law. That instead of doing what we used to do, and that is saying that the employer violated the election rules, but they weren't too terrible, they just did a little bit of this, we're going to let the employees vote again and have have a chance to vote as to whether they wanted to have a union or not. That's not going to happen anymore. Under Cemex, if the employer asks for the election, is found to engage in an objectionable conduct, and the employer wins, the employer still has to recognize the union. So the employer gets a bargaining order, even though it won the election, and even though it didn't do a whole lot of terrible things, it just did a little bit of terrible things. And so what this does is this places a great emphasis on the need to have compliant policies and handbooks. We'll go to the next slide. And the reason that it puts this need on having compliant policies and handbooks is in Cemex itself, it basically acknowledged that handbooks and policies can be the type of conduct which not only sets aside the election that the employer asked for, but ends up in a bargaining order. So you could theoretically have a handbook which had one improper rule, one neutral rule that says we're to treat all of our employees with respect and dignity, that you did not enforce that rule during the election process, and you never enforced that rule, and you never made any reference to it during the entire election. There is a possibility that that rule will be found to be unlawful under Stericycle, and that because you maintained it, even though you didn't enforce it during the election period, that not only sets aside the election, but it causes you to waive your right to an election, and you end up with an employee represented by a union. So there are a lot of issues that are going to be open. There's going to be what is the standard of the violation or the objectionable conduct that you have to have under Cemex to end up losing your rights. There's going to be a question as to when the union says it's got a majority status, what's the employer's right? Does the employer get to count the cards? Does the employer get to cross-examine people on the witness stand as to why did you sign it? Were you bribed? Were you threatened? Is this your signature? Are you going to have the right in an NLRB process to go back to the improper rule or policy and say, well, was this a reasonable employee, and put on evidence from workplace psychologists, though a reasonable employee would not be concerned about this. This is not how a reasonable employee would interpret it. So there are a whole lot of legal issues, and so that means you should continue to watch our blogs and alerts, and you'll find out the answers as they come in the next decade or so. Thank you.
Next slide. Thanks, Jeff. So now that we know why handbooks are so critically important, we are going to talk about what we know to be on the NLRB's radar. And one thing I want to clarify, if it's not already clear, is everything we're talking about today applies to virtually all employers. So please do not leave this webinar today thinking, well, I don't have a union, I don't have to worry about any of this, or I don't have any union activity, I don't have to worry about this. This applies to virtually all of you, and so I want to make sure that we're all clear about that. Next slide, please. So Jeff had already talked about sort of the most popular provisions that we think are going to be on the NLRB's radar, as Chelsea showed us with her hat trick over there. When I put on my labor lawyer hat and am asked to review a handbook, these are the policies that I always go to first. With respect to confidentiality, another issue that's missing is maybe there's a confidentiality provision in a non-disclosure agreement, and a lot of times those agreements have a definition of confidential information, and so I'll look for Does that definition include anything about terms and conditions of employment? I sometimes see language that says confidential information includes trade secrets, proprietary information, and any information about employees, for example, which would be problematic because employees are allowed to talk about other employees' wages, benefits, terms and conditions of employment. Social media policies, solicitation and distribution policies, and handbooks typically are included in one policy. I need to close the chat because I'm getting distracted, sorry. Media policy, so that would be a policy that says you're not allowed to talk to the media. There are ways to have policies like that without violating Section 7. Civility rules, Jeff talked a lot about those. You have to keep in mind, too, that even if you don't have a civility rule documented, I think that most employers do, you have to also make sure that, as Jeff talked about, and we'll talk about a case specific on this, if somebody is acting in a way that you don't feel to be civil, for lack of a better term, and you think about disciplining or terminating them, that's something you now have to reconsider under this new board standards. Next slide, please. So I wanted to just kind of give you a highlight of all of the policies that were at issue in Stericycle. I'm not going to go through all of them. I do think that some of them are, in my view, obvious, at least under an Obama standard. For example, conflicts of interest policies can be problematic because arguably if an employee reaches out to a union and tries to bring a union in, obviously the NLRB and the employer are going to make the argument, and the union will make the argument that they're doing something that possibly impacts the company, and so that could be a problem under a conflict of interest policy. And then the policy prohibiting employees from disclosing complaints in the terms of their resolution, that's definitely a huge no-no under the Obama board, and definitely will be problematic under the new Stericycle decision. Next slide, please. So what I want to do is talk about a couple of decisions that came out of the Trump board. We had some Chair McFerrin dissents, and so we have an idea of where we might be going. With respect to confidentiality during investigations, the key Trump board decision on this was a decision called, hopefully I'm saying it right, apogee. Confidentiality rules, according to that decision under the Trump board, that by their terms apply only to open investigations are unlawful. So that would be, at least under the Trump's view of the world, if you're conducting an investigation and you tell employees to keep it confidential during the investigation while it's still open, that's okay. But once the investigation ends, then the employer really has no interest in keeping it confidential. We do know that McFerrin would want to go back to the way it was before apogee. So under the Obama board, it was an employer could demand confidentiality during an investigation, but that was analyzed under a case-by-case basis. So prior to apogee, they didn't have a bright line rule. We'd like to think that maybe McFerrin is going to go back to this, or the board will go back to this case-by-case standard. Under Stericycle, we feel like we really can't predict anything anymore. So we are aware of a case that is going to be coming out. We've been waiting. Jeff and I have actually already written a blog on it, so we're just waiting for it to come out on this very issue. So as soon as it does, we will be releasing something on that. IT systems is a huge issue, and this discussion encompasses both use of employer technology, so the networks, the internet, things like that while at work, but really what it comes up in the context most with emails. So can you have a rule prohibiting employees from using, so, I'm not the best example, but, could Cyfarth have a rule that says I'm not allowed to use my Cyfarth email for personal reasons, stuff like that. So that would be an example. And Purple Communications was the Obama decision that was very employer-friendly on that issue, but the Trump board and Caesars Entertainment came out with a rule that said employers can restrict employees from using IT email absent proof employees are otherwise deprived of reasonable means of communication with other employees. So what does this mean? So under the Trump standard, an employer could have a rule that employees can't use email for personal or any reason you know, if employees are allowed to talk about these issues during their break time and which obviously they're allowed to, but as long as there's, you know, maybe a break room, they're able to talk about these issues outside in the parking lot. They have personal emails and they're communicating that way. So as long as under this view of the standard, employees are able to engage in Section 7 activity and other forums, then an employer could, under this standard, prohibit employees from using email. We know that Jennifer Abruzzo, and when we all say Jennifer, we're not talking about me, we're talking about Jennifer Abruzzo. She wants to, at least we think, we've seen some signs that she wants to be able to allow employees to use company email for any reason. Whether or not the board is going to go that far, we don't know. It's possible they just go back to Purple Communications, which I suppose is going to be, you know, maybe a better standard than, you know, everybody can use it anytime, any place, for any purpose. The other issue, too, in prior decisions, it's always focused on employee use, but now we have different employee communication channels that employers are monitoring. So, for example, Slack. So whether or not employers can prohibit employees from using Slack, I imagine that the analysis with respect to email will apply to Slack as well. Next slide. Okay, social media is, you know, a huge issue. Right now, rules that restrict who can speak on the employer's behalf on social media are facially lawful. Rules that restrict the use of the employer's name as part of a social media account, they're evaluated on a case-by-case basis. We do think that these decisions are going to definitely be, or the ones that come out on social media are definitely going to be far more employee friendly. We are already aware of one decision that the board, since Stericycle came out, has now remanded to the ALJ. So the decision was decided at the ALJ level under Boeing. The rule in that case said that when publishing content on any social media channel, and the company tried to distinguish between professional channels like LinkedIn and non-professional channels like Instagram and Facebook, the rule said that employees could not, quote, refer to or identify a company customer or client, end quote. And so the ALJ in that decision was analyzing this under Boeing. And so if we remember, Boeing says you look at, does the employer have a legitimate business reason for the rule? And then you look at, would an employee reasonably view the rule as interfering with Section 7 activity? And then you do a balancing test. And in that decision, and what's critical here is because the ALJ in that decision found the rule that says employees cannot refer to or identify employer customers as, or clients as violating Section 7 rights. The reason the employer won in that case is because the employer convinced the ALJ that it had a legitimate business reason for the rule. Now, you might be asking yourself, why is it okay for an employee to go out and talk about my customers or my clients? And the ALJ, I was just reading the decision this morning, gave an interesting example, which is that these employees were out doing remodels at residential homes. And what if an employee, according to the ALJ, wanted to complain about Facebook about this pit bull that was in the backyard, and the employee was scared of the dog and wanted to be able to complain to other employees or even the public about the fact that he or she had to work in an environment where there was a vicious dog. So if a rule under Boeing was found to be unlawful, but the employer won because it had a legitimate reason for the rule, we know that it's going to be unlawful under Stericycle because, as Jeff mentioned to you, it doesn't matter what our reason is for the rule, right? So, you know, keep that in mind as you're looking at your social media policies, because when I read that, I thought, I don't understand what the problem is with that rule, right? We don't go around and talk about, you know, clients, or we don't talk about company customers or clients. What's the problem? So now we know there's apparently a vicious dog out there that somebody might want to complain about. So that's what we possibly will see with respect to social media. And then recording rules, I'm actually dealing with a no recording rule in a region in Texas. The NLRB is investigating that. And those are rules that say, you know, you can't record, whether by audio or video, things that are going on at work, stuff like that. So these were found to be lawful in Boeing, and Boeing actually, the Boeing case that came out actually was analyzing a no recording rule when it came out with its standard. And so we think, again, unless an employer has a really, really, really good reason for a no recording policy, and as you can see from Jeff's discussion about how hard it is to meet the Stericycle standard, that's another one that you're definitely going to want to be looking at. So with that, I'm going to turn it over to Chelsea, who is going to wrap it all up for us.
Thanks so much, Jen. Let's go ahead and get to the next slide.
Actually, I think I have one more.
I was going to say that one's you, Jen.
Sorry, one more.
One
So
more.
aside from what we expect to happen, we can actually talk about two cases where we've already seen this in an issue. So in February, the NLRB held that the simple act of presenting a draft severance agreement containing a broad confidentiality non-disparagement provision violates the act. The provisions in that law, in that decision or that particular case were very, very broad, I will say that. So it remains to be seen how the board is going to view agreements that have language that is more narrowly tailored. But again, and we don't know if it's going to be analyzed under Stericycle. Jeff mentioned that Stericycle focuses on the facially neutral rules, so I suppose that's probably the standard they'll use for confidentiality, non-disparagement, and separation and settlement agreements. But that's just something to watch out for. We've put out some blogs on the McLaren decision. So and keep in mind, too, that the NLRA does not protect managers and supervisors. So you can at least ignore this particular issue with respect to people that you know are statutory supervisors under the Act, right? Just because you call somebody a supervisor doesn't necessarily mean the board agrees with you. But this is only going to apply to your statutory employees. But still, you're going to need to be careful about that. In the profanity decision, and Jeff was talking a lot about this with respect to civility, the board held that employees have broad leeway to make lewd, lascivious, racist, or other inappropriate comments at work, so long as those comments are connected in some way to hours, terms, and conditions of employment. This goes far beyond, again, as I mentioned, a written policy. You know, I think that it goes without saying that employers expect their employees to act act in a civil, respectful, cordial manner at work. And, you know, a lot of employers don't feel like they should really have that documented because it seems like common sense. So, you know, going forward under this decision, if you ever have an employee engage in this type of conduct, you're going to want to make sure that you possibly reach out to your counsel, reach out to your in-house legal, and talk with them about it first. You know, according to this decision, apparently it's okay to use a racial slur that could expose an employer to a federal or state harassment or discrimination claim, so long as that person was using the racial epithet while complaining about terms and conditions and wages. So it really puts employers between a rock and a hard place. And I do believe I think there are some appeals over this particular decision because the conflict between this and EEO laws really is rather unfortunate. And I suppose at some point employers just have to make a decision. Do they want to deal with the NLRB or the EEOC? And that's not a great place to be. So work with your counsel anytime you're dealing with these particular situations. And now I will turn it over to Chelsea. Thank you.
Yeah, thanks very much, Jen. So on the next slide, one of the things that we're generally recommending is to really take this opportunity now that we're at the end of the year, now that we've got a good understanding, or at least a better understanding of what these cases mean and what the legislative sessions across the country have done. It's probably a good time to be looking at your policies anyways, but we really should be asking ourselves a series of questions with really, especially the policies that Jen mentioned, the policies that we think are the most ripe for concern, but really every policy in your policy manual or your handbook, you know, and ask yourself, number one, what is it that we are trying to protect with that policy? What are we trying to accomplish with that policy? And then whether that policy and the way that it's written is really necessary. Will you be able to, if you are called on by the NLRB or ALJ or whoever, a grumpy employee, to justify the rule or the policy, do you have the ability to explain it? And is that justification anywhere in writing? And really take into consideration, is there a way that we can recraft this policy that includes that justification within the policy, so that not only are you reading what the protection is, but why we need the protection. And so if that means we need a little bit more prefatory language or a little bit more of an explanation within the policies that we're drafting, that's okay, because the whole goal is to make sure that it's clear on its face, because that's all they're going to have if they're really examining the policy, is did we explain why we need it, and to make sure that that need has nothing to do with limiting any rights under the NLRA or employees' rights otherwise. And so even the idea of using illustrative examples, I know if y'all can think back to some of the old general counsel memos under the Obama board, the one that comes to mind that has all of the examples of things that you can include in policies that will actually help explain, again, on its face, what we mean and what we don't mean. Calling back to that and giving it another consideration. So as you are reviewing or as you are drafting, including an example can be really useful. And we know, the NLRB likes to see that, because it helps them understand what is it you're trying to accomplish, but more importantly, what you're not trying to do. And so that can be really good if you can think about illustrative examples and really include those in your policies. And of course, I get the question all the time. I probably get this question with every handbook that I look at. Can't we just include these savings clauses or disclaimers? And, disclaimers are a mixed bag, in that we know a disclaimer on its own is not going to be sufficient. There is memo after memo that says throwing in a disclaimer in your handbook is just not going to save you at the end of the day. We should obviously be looking to make our policies as good and as tight as we can, and following the rules that have been set out, and the cases that we're expecting to see as they come through. And so know that we need to do that first, but that doesn't mean that we shouldn't also use a disclaimer. And Jeff and Jen and I and many of our colleagues have gone back and forth on language that we think is good or better in terms of a disclaimer. And so making sure that we're calling out in a variety of places that our intention is not to interfere with various rights, and listing out some of those rights, I think is a really good also but not on its own. It's the belt and suspenders approach, but also adding, a rope around the waist and stapling the suspenders in place. And so by adding this additional language, it definitely puts us in a better place. And of course, be wary though of the general counsel's invitation to use that prophylactic language. I took another look at the suggestion in the memo that came out in March of 2023 after McLaren, and it's a laundry list of things that we can include to really lay out all of an employee's or potential rights that are being protected. And it is, it's about this big. I had to pull it up again this morning, and the NLRB's website was down for quite some time, so I wasn't able to get a look at it. But looking at it again just reminded me at how lengthy and how inclusive that list is. And so having something like that in a handbook may not feel like it makes the best sense, but it is out there if anyone's looking for suggestions of what are some of the rights that they're talking about in terms of this prophylactic language. On the next slide, other things to be asking yourself as you are doing this review, if you're going through these, ask yourself these questions, because some of these are easy. If you find the answer is yes, then you've got things that you need to change. But really asking these series of questions. Does your policy, practice, or agreement, and we're talking about looking at all three of those, implicitly or explicitly do any of the following? Does it restrict an employee's access to the NLRB? Obviously, that's a concern. Does it prohibit employee discussions with the NLRB or others? Is it going to prohibit an employee from discussing the terms and conditions of their employment? And when we say that, we're talking about their wages, their hours, their working conditions, their benefits, their safety, really anything that goes into the life cycle or the experience of an employee within your employment. Is this something that's going to tell them they're not allowed to talk about it? Or does it prohibit employee discussions about settlements or arbitral proceedings with the NLRB or their union? And to Jen's point, we're talking about what we were talking about earlier. Does it prohibit employee witnesses from talking about internal investigations? And is it going to have some sort of blanket prohibition about an employee speaking to the media at all and under any circumstances, or regulate what employees can post in their social media, or deny third parties access to all of company property at all times. These are things that we should be really looking at and paying attention to, and flagging, so that if there are questions about your policies and you're working through your policies, you can have an idea of which of those policies may raise a concern, and merit discussion with your favorite labor lawyer and your favorite member of handbook team. And so on the next slide, I'm sure what all of y'all are asking yourselves is, in the face of all of this, and even Jeff mentioning at the very beginning, why have a handbook? And I implore you, this is not the time to simply throw your handbooks out the window and not have them anymore. We know there are a lot of reasons why having a handbook is still a best practice, and why we really do encourage all of our clients and all employers to have them. They are such a good opportunity to establish those uniform expectations, and so employees at least have a general sense of what they can expect. It's very difficult to hold employees accountable to standards if they don't know what those standards are. And so not having a handbook at all, not having policies at all, puts you in a position where there's just sort of a free-for-all in terms of behavior. And it gives us an opportunity also to get that acknowledgement of an understanding of what those expectations from employees. And I think that's a really good opportunity. It helps when you're trying to enforce those expectations, as I mentioned, to prove that they had notice of it, that they understood it, that the expectation was they were going to read it, et cetera. It also gives us an opportunity to show off a little bit, to showcase what your benefits are, what the wonderful things that you do for your employees are, the ways in which you are being good to them and generous to them. And so that's a great thing to have in your handbook as well, and to give your employees something that they can rely on. Also gives you the opportunity to achieve some organizational consistency and reduce the risk that you're going to have your supervisors just going rogue and doing whatever they want because they don't have any guidance on how certain things should be handled. And so we can minimize that to a certain degree if we lay out what those rules are and what our expectations are in a handbook. And of course, there are legal things that are supposed to be included in a handbook. There are various laws across the country that actually include a requirement for a written policy at the federal and state level. And so a handbook gives us the opportunity, and really the best opportunity, to gather those together and present those to an employee. And it also allows us to recommunicate our expectations as an at-will employer and that at-will relationship, as well as whether or not we're using arbitration in our employment. Highlighting that in the handbook is a good way to do that. And clearly, we're not intending for our handbook to be a contract of employment, but it really does serve as a reliable guidepost. It is that guidepost for our employees so that they can understand, what they can expect and what they will be able to do and not do within their employment from a very general level, and put everybody at least starting on the same foundation. And so a handbook is a good way to do that. I'd also like to use this as an opportunity on the next slide just to talk a little bit about the handbook team. I know many of you are familiar. I see a lot of familiar names on our attendee list, so many of you know about our handbook team. We do have a large group of experts that are trained in handbooks and drafting of policies in every single one of our offices at every level that we've got attorneys. And we do use this team both as an internal resource for ourselves, as well as an external resource for building these projects for y'all. And so it means that we've been able to create a really nice and customizable national template and state addenda for every single state, even those that don't have the written policy requirements, just in case clients want those. And we have a questionnaire for employers so that we can very easily and efficiently tailor these handbooks and state addenda. We partner and work very closely with our paid sick leave team and our paid family leave teams, our leave management teams, so that we're really assisting in efficiently managing these national resources in those spaces as well. We do have a couple of webinars coming up in the handbook space that I wanted y'all to be aware of as well. You may already know that next week, next Thursday, that's the 26th, from 10 to 11 Pacific, we are doing a what has happened in the world of policies for 2024. And so I'll be joined by several of my handbook team members. We can talk about what y'all will need to update for 2024 handbooks. We're also doing a paid sick leave webinar the day before from 12 to 1 on the 25th. That's going to talk about our paid sick leave offerings and what's new and notable in the paid sick leave space as well. We're also doing a Cemex webinar on November 29th that Jen will be involved with as well. That's going to be noon Pacific Standard Time on November the 29th. So on the next slide, a few closing thoughts, things to look forward to, of course. We know that the cases are going to be remanded so that the ALJs are going to be taking another look at whether a work rule or policy is going to be able to pass muster under Stericycle. So it's a really good idea to set your ticklers, to set your notifications so that you are tracking these decisions, because we know they will be informative. There wasn't a lot of really strong guidance in Stericycle about exactly what we should be doing, exactly what we should be looking for. So these decisions are going to give us a great opportunity to learn more about what the board is intending with respect to certain policies. But it is a great plan to be reviewing your handbooks and policies now. And of course, be mindful when you're considering discipline or termination based on a work rule or policy, reminding your supervisors and managers to consult with HR or legal before they're making disciplinary decisions, because if they're doing it based on a policy that on its face would not pass muster, or we believe would not pass muster under Stericycle, obviously per Jeff and Jen's discussions, we know that can be very problematic for an employer. So that's something that we want to be making sure our supervisors and managers are aware of as well. On our next slide, we've got, I believe, our CLE code for those of y'all who are looking for it, and that is SS as in Seyfarth Shaw, so SS 7871. I'll repeat that. It is SS as in Seyfarth Shaw 7871. With that, Jeff, Jen, anything you want to add before we wrap up for our day?
I just a couple of things. First of all, we haven't heard the last word on all of this. Some of these decisions have been or will be going to the federal courts of appeal to test whether or not the NLRB is right. We used to go to the DC circuit, and we got a lot of very favorable employer decisions out of there, but the makeup of the DC circuit has changed slightly, and it's not necessarily a win there. Secondly, on these disclaimers, there's another reason to have them, I think, and that is, if the standard is the reasonable employee, how can the reasonable employee say that a rule of civility infringes on my Section 7 rights when down at the bottom of the page it says that none of this is supposed to interfere with your Section 7 rights? And that theory hasn't been tested. The Labor Board is not going to like any disclaimer that you do, except maybe the one approved by Jennifer Abruzzo. But maybe the courts of appeal will have more common sense than the NLRB. There was also a question on remedies. And it used to be that we weren't so concerned about handbook violations, because if you had a handbook violation, what does it mean? It means that you have to post a little notice on the bulletin board saying you were a bad employer and you won't do it again, and change the rule. But now the ante has gone up in two regards. One is this Cemex case, and that is if you've got an election and you win the election, you may lose the right to have an election and have to recognize the union. But also, if you took action against the employee, an employee for, say, breaching the civility rule or breaching your EEO rule about no racial comments, that under the NLRB, they are expanding their remedies. So it used to be that the remedy for an employee who was improperly discharged would be reinstatement with back pay. Now, the Labor Board is starting to extend that, so it is lots of other things. So for example, if my credit score goes down because I've lost my job, the employer may be required to, reimburse the employee for the loss of the credit score. If my car was taken back because I couldn't make my payments, may have to do something like that. So the ante on all of this stuff has become it's gone up much greater than it used to be. So it's very important to look at all these rules and policies and do what you can, knowing that common sense probably plays no role in any of this.
Awesome. Thank you so much, Jeff. Jen, any closing thoughts before we wrap up for the day? No?
No,
All right.
we had a great time. We're so glad you all joined us today. If you have any follow-ups, I think we have some questions in the chat we can follow up with, but our contact info is on the slide, and if you want to reach out to any of us or any member on your Seyfarth team, we would love to hear from you. So thank you all again.
Thanks so much. Have a great day, everyone.